Hey, I'm Marc Stevens, author of Government Indicted. The website, of course, is markstevens.net. And love to do these. Got another success story, and this is a good one. This is not just a run-of-the-mill traffic. It's criminal traffic, and it's a win or a success story from an appeal. She was originally convicted. So this is going to go on to the success stories. But Mike, MJ is the one who actually went through this. So Mike, it was Mike's wife. Mike had a ticket dismissed in Texas last year, October 15, 2014. We posted this. And I have the order of dismissal. There it is right there. We're glad that he sent that. And it was dismissed for insufficient evidence. Insufficient evidence because there wasn't any evidence to support the prosecution's claim or the police officer's claim that just because Mike was physically in Texas, that the laws apply to him. And so that was thrown out. So now we've got his wife, who Mike helped through this. And as I mentioned, this is an appeal, so we're going to show you the documents here. She was initially arrested. Again, this is criminal. That's why she's arrested. This is in Harris County, I guess in the city of Webster. And she was pulled out of the car. Yeah, there's Webster, Texas. And she was falsely imprisoned and held for a ransom. She was kidnapped, falsely imprisoned, and held for a ransom of $505. And she would not be released. I know a lot of people use the double standard, but they're the government. But, I don't give them a free pass. If it's wrong for me to pull somebody out of their car, take them against their will, and hold them for a certain amount of money, and I won't release them until they pay me, yeah, that's called kidnapping. That's a crime. So I don't allow for a double standard, especially since here when people may say, well, they got the law. No, they don't. So just like what we showed here with Mike, let's see, where is that? Yeah, it's in the video that the case was dismissed for insufficient evidence. There is no damn evidence to show that just because you're physically in Texas, their laws apply. So they don't have that excuse. So the double standard, totally bogus. MJ's first language is not English, so when she did go to trial, she was bullied and abused by the judge. I know. There's a shock. But this Glenn Chaney of the municipal court in Texas, where she was convicted, so the defendant found guilty at a jury trial. Just let you know, just because you have a jury don't mean it's going to be fair by a long shot. She was found guilty, and so he bullied her, didn't allow cross-examination, which is standard. Prosecution didn't have a shred of evidence and didn't even try to claim that the witness was qualified to make legal determinations, such as if you're physically in Texas, the laws apply to you, although that's what he testified to doing. But she was also mocked. The judge said things such as, well, what does corpus delicti mean to you? And they do that commonly also with the issue of jurisdiction to kind of shift the burden and push it back on us. So what I recommend doing is just throwing it back on them. Hey, jurisdiction means whatever the hell you think it means. However you're using it as applied to me, that's what I'm going to go with. Because that doesn't change. They're still saying they have jurisdiction, whatever that happens to mean, and they still have to have evidence to prove that. And however they define it, they're not going to have a shred of evidence. Because bottom line, it still comes down to this. Territorial jurisdiction, there's that word again, is based on your physical location, nothing else. So we'll see that here with MJ, political status had nothing to do with it. Because it says right here, U.S. citizen, unknown. So her political status wasn't even known. And she was still able to get this dismissed. So what we'll do is we'll go through. They go up on appeal. They get a trial de novo set. So they filed a motion to dismiss. So let's just pull that up. So we've got the motion to dismiss there. And then they also filed a request for discovery. I believe this other motion to dismiss was for prosecutorial misconduct, because again, as I say so many times, there's no evidence to show that just because you're physically in Texas, their laws apply to you. It's just a bold or a blunt assertion, to borrow a phrase, to quote Robert Diab. So what we have happen is we have to go by the testimony of MJ and Mike, because the prosecution is, it just says other. They don't want to put down why. We have, I see it's dismissed. You could see that it is a misdemeanor. It is criminal because, and we'll get to there's the dismissal itself. The prosecution actually filed a motion to dismiss. And they put down here, other, see state's file. But The only thing you could find is that the only thing we know for sure, because and Mike was able to report this, is because the police officer, despite being under subpoena, did not show up for a misdemeanor trial. Now, you and I do that. We have a motion. We have a warrant for our arrest, and we could deal with a possible contempt charge. All the judge did here was grant the motion to dismiss, which was nice, which is great. That's what they wanted. But I just want to address a couple of points. People may say it just was too much trouble. Really, it's a misdemeanor misdemeanor trial. He was under subpoena. Or, and we don't know this because we don't have any copies, maybe the prosecution just didn't subpoena the police officer, and that's why the police officer wasn't there. Maybe because, maybe they thought, well, maybe it's too much trouble because we don't have any evidence. Because why would it be so much trouble to deal with somebody asking for evidence to prove your laws apply? If it's so obvious that the laws do apply, why would that be so much trouble? You wouldn't subpoena the police officer, and if you did subpoena the police officer, you would tell him not to show up, or he just wouldn't bother. If it was a slam dunk, see, it contradicts. It doesn't make any sense to say it's too much trouble, especially when they already had a conviction. No. The fact remains, and the circumstantial evidence is clear, because the cop blew off a summons for a criminal trial. If they had the evidence, if the cop was qualified and had personal knowledge of facts proving that the Constitution laws apply because she was physically in Texas, they would have just provided it and got a slam dunk conviction like they already did. So the arguments against it, as usual, they just don't hold any water. So big congratulations to Mike and MJ for sending us this documentary proof. I'll have the documents here on markstevens.net, just like I did here, all the documentary proof. So if you can't see it in the video, you could just go to markstevens.net and you can get copies of the documents there. But big congratulations. We'll get it here under the success stories. But if you disagree with what I'm presenting, if you think that, and you have evidence to prove this, if you think that just because MJ or Mike are physically in Texas that the laws apply, man, I want to see the evidence. And if it's one of these things where you're saying, we don't have to prove that, then that's proof of a rigged game. Because if you can't challenge it or you don't have to prove it, by definition, that's a rigged game. That's just not fair. But hey, I'd love to have you call a live broadcast. We're live every Saturday from 4 to 7 Eastern Standard Time on the Liberty Radio Network, and you can present your evidence. I'd love to hear it. Again, my name's Marc Stevens, the website, markstevens.net.